Justice and Correctional Services Minister Ronald Lamola says he will help #fees must fall activist Kanya Cekeshe to get a presidential pardon. The Johannesburg Magistrate's Court yesterday dismissed Cekeshe's application for leave to appeal his conviction. The magistrate also dismissed his application to be released on bail. The student activist was given an 8-year sentence for pleading guilty to setting a police van on fire during the height of the student protests in 2016. His current legal team argue that he'd been misrepresented by his former lawyers when he pleaded guilty. Let's get to the bottom of this, and joining us from our Pretoria studios, we've got Silas Siphuma. He's a senior lecturer in jurisprudence at the University of South Africa, or UNISA, to elaborate a little on this matter. Good to have you, Silas. Thanks so much for joining us.
Thank you for having me. Good morning to you too.
Cekeshe has been in prison since 2017 after being sentenced to an 8-year prison term, of which 3 years was suspended. Do you think that this was a fair sentence considering the crime?
Considering the crime, one would prima facie think that it's not a fair sentence. And now that the matter has been brought forward that he was not well represented by his first legal team, one starts to wonder what went wrong and whether when he entered into plea of guilty, was he aware of how everything will turn out or on the ill advice from the lawyer. But now that the matter has been raised, one will expect that the court or the magistrate court will have more to listen to his team, his legal team, to hear what went wrong, since the the Criminal Procedure Act, Section 112, provides that one must have a fair trial.
So his legal team, as you yourself have said, that they're insisting that there's not enough evidence against him and that he should never have pleaded guilty, and that's what he did under the guidance of his previous legal team. Is this strong enough? I mean, how important are these points in this case to turn his plea around at this point?
The importance of such argument is that, but as soon as he's not pleading guilty, then the burden of proof now shifts to the other side, which is the state. And as you might have seen yesterday, that Advocate Ngogai Tombi have argued that there is no strong evidence against the accused. So this will mean that if now the magistrate had allowed them to change their plea from guilty not to guilty, then this will mean now that the state have more to prove. And as it transpired yesterday, as you have seen, they are arguing that there is no evidence from the state side. They don't have videos, they don't have photos. So then the state will have more case to prove than it had, because once you plead guilty, then the state doesn't have to do much. Yeah. And that's how the ill-advised part come in. So we really think that if the magistrate could have allowed that possibility, now the trial would have been fair, because now the argument is that the trial was not fair because the student was ill-advised. Yeah. And as this is protected by the Constitution, by Section 9 of the Constitution, which provides that everyone is equal before the law and that everyone must have a fair hearing, this will mean that the student case was not fair. I mean, the trial was not fair. So I think this is very important question that, or the argument to say that is raised by his new legal team.
So is this quite common practice where you'll see that due to illegal advice, you change your plea? Because once you've pleaded guilty, I suppose one would have assumed that that's the end of it. But now we're learning, and I mean, I'm talking to people that are not lawyers or experts on law, that it actually, in fact, due to that ill advice, you can actually change your plea. Is this allowed?
Yes, I mean, it's also questionable at this stage because the Section 112 of the Criminal Procedure Act provides that once the accused by himself or through his legal representatives enter a plea of guilty, the magistrate or the judge have a discretion to inquire more on whether the accused understand what this means. So if the judge or the magistrate is still not satisfied that this plea of guilty is correct, or whether the accused is advised well, you can inquire more by questioning the accused. So now we wonder whether this was done at the first place. And if it's not, then the trial have not been fair. And what do we do at this stage?
Yeah, interesting.
That's when that's when Advocate Ngogai Tombi argument comes in. Can we set this aside for now and have a proper advice? And given the nature of the crime that the accused is being accused of, we're not saying the criminality is encouraged, but the circumstances surrounding the whole situation, it begs for different kind of approach. And this is the opportunity that one can get when you have a good lawyer, a good advice, and then this will set a good precedent for our law.
Yeah. Very, very quickly, the presidential pardon. So on what basis do you believe that Justice and Correctional Services Minister Ronald Lamola has suggested that he apply for a presidential pardon, and what does that actually entail?
Well, that's an interesting part now that the new Justice Minister want to assist the student to apply for presidential pardoning. But in my understanding, this is how it works. Basically, not the minister or the department applies, but they can assist with the process of how the accused or the guilty party can go through the process of applying for presidential pardon. But one start to wonder now, I mean, this matter has been going for long. And this, what is at the stake here is the student's future and the impact it has. So you start to wonder whether is this a genuine approach, or is this because of the other political pressure. But it will be great to see that the justice is served, and the justice is not just be done, it's seen to be served. And at the end of the day, we understand these rules are strict, and the whole legal system have more to do with being strict for certainty purposes. But one will question, what is the law, and is the law there for people, or the people are there for the law? In my firm belief, the law should be there for the people, not people there for the law. Then the law should serve the interest of the society. But is this the one, that the situation where the law is serving the interest of the society? Given the fact of the surrounding circumstances around this case, is the law serving the society? If not, then is there any opportunity that the law can still serve the society? Then the argument by the new legal team comes in. Can the matter be viewed from another lens? Well, if so, then will the outcome change?
That's what we wait and see. But thanks so much for giving us a better understanding of what's actually taking place now. So this is certainly going to be one to watch. And from what we're gathering, this is going to work quite quickly for him. So thanks very much. That was Senior Lecturer in Jurisprudence at UNISA, Silas Siphuma, talking to us about the new developments of Kanya Cekeshe, the incarcerated fees must fall activist, and talk of a presidential pardon, or at least applying for one from the minister.